I am a lawyer, but I am not necessarily your lawyer. The materials discussed in this podcast are for informational purposes only and should not be deemed legal advice. If you have a specific legal question according to your circumstances, then I encourage you to speak with an attorney licensed in your jurisdiction. All right, welcome back to Ag Law Today, and we have a very special guest, Deborah Kaminetzky, all the way from New York, and she's going to be talking about last will and testaments today. Deborah, why don't you start off and give us a little overview of your law practice?
Thanks, Cari. I started my own practice in 2009, and we primarily do estate planning and matrimonial mediation. We also do prenuptial agreements, which is a hybrid of the two types of practice.
So Deborah was actually a mentor of mine way back in the day. She handheld me through my very first divorce quite a few years ago. We won't say how many, Deborah. But let's talk a little bit more about last will and testaments today. And let's start at the basics. What exactly is a will?
A will is a document that expresses the testator's wishes with regard to their personal property, their money, and who they want to be in charge of those things. If they have minor children, they can also designate guardians for them.
And we can get into the nitty-gritty of this a little bit later, but couldn't that just be a letter? Or how does it differ than just somebody sitting down and writing a letter on what they want to happen with their estate?
Okay, in New York, which is where I practice, you need to have witnesses to actually sign the will also, and that would make it a valid will. And we also normally include a self-proving affidavit, which is also notarized.
All right, so we've all heard these stories of people writing their last will and testament on a bar napkin. Are handwritten wills really enforceable?
Where I am, they would not be, and I have to be honest with you, I don't think at a bar is an appropriate place to make these decisions anyway. But you definitely need those witnesses, and the self-proving affidavit makes the court more likely to accept the probate of that will.
How do you think that wills fit into the big estate planning process?
The will is only a part of the process. It only takes effect once the testator dies. There are other documents which are important when you're alive, such as a healthcare proxy, a power of attorney, and a living will. These documents will serve you while you're alive so that if you become incapacitated, your family doesn't have to spend the money or the time to have a guardian appointed. I am an advocate of estate planning for college students as well, because once they turn 18, they're adults in the eyes of the law. My blog post, What Should Be on Every College Student's Back to School List but Probably Isn't, found at my website, KaminetzkyLaw.com, gives details onto why this is so important. And yes, my children have their plans in order.
Yes, I've seen it on the other side of things on what happens if you don't have a power of attorney. It's just such a simple thing to get done. And why do you think that people don't get it done?
I think that a lot of people don't get it done because they do not want to contemplate their death. I happen to have had cancer in 2010. Obviously, I'm still here, but I think that made a big difference in my way of thinking. But even though it's not a fun thing to do, I think once you do get it done with the advice of an attorney, you will have finished and have that peace of mind.
All right, let's get in a little bit more in the details. What, in your opinion, are the major considerations in a last will and testament?
The major considerations obviously are guardians of children. They have to think about what they want to leave and to who they want to leave it and how much and in which proportions. When we have a client in the office, we do a family tree to make sure that we're considering everyone that they would normally be leaving it to if they didn't have a will. And we also then discuss what they wish to do and why.
Is it okay for people to disinherit particular family members?
It's fine with me. They need to think about that. I sometimes ask them why they're looking to do it. Sometimes it's because they already bought, let's say, one child a house and so they feel they don't need it as much, something like that. But yes, you can definitely disinherit, but there's better and worse ways to do it. I don't know how far you want me to get into something like an interorum clause, but what we do with those is if you are leaving somebody less, you can say that if they decide to go to court and fight it, they might lose what you are leaving them, and so that gives them a real disincentive to fight.
And what about spouses? Can you disinherit your spouse?
In New York, we have something called a right of election, where if you do write a will that leaves your spouse out, they can get $50,000 plus a third of the estate. And that's one of the reasons why when we do divorces, we're very careful about having a waiver of estate in the agreement. Because if they're still married and you have not done that, in theory, they could inherit.
Yeah, and the law differs on that definitely from state to state. I know in Illinois it's not 50,000 or 1/3. I think it's just 50,000. So let's talk about a little bit who's who. Who is the executor of the estate that's mentioned in the will?
The executor is the person who must take care of the estate, make sure that the items are either given to the people who are supposed to get them or sell them and divide the money properly. Sometimes they need to step into the shoes of the testator and run their house, pay their bills, etc.
All right. So when a person is drafting a last will and testament and they're trying to decide who should be the executor, what are some considerations?
Well, one of the considerations is trust. They want to make sure that's someone that they feel will do what it is that they want as opposed to what the person wants. They also need to have the knowledge on how to get everything done. Frequently, clients will choose co-executors for that reason. They want to make sure that they have one party who they can trust and the other party who knows what to do.
That's a good example. I never even thought about that. So when you draft wills, how far down do you go? Do you put in a contingent executor, a successor contingent executor? How far down should people consider?
We try to do at least 3. So there's whoever's named as the first executor, then a secondary, and then a third one. Now these might be 2 different people working together, but we try to have 3 different ones. And we also always try to have them be of the younger generation, with the idea being that that person is likely to outlive the testator and be able to function. I would never advise to have the executor be all of the older generation.
That's a good point. All right, so let's talk a little bit about payment. Do executors get paid?
They do if the testator wants them to. We can include language that says that the executor can take an executor commission, or we can say that they don't. Normally, we also advise people to discuss with the people they want to be their executor what it would entail to find out if they want to do this job, and they may ask, do we get paid? And
so when you say executor commission, is it based on the size of the estate? Is it based on hours? How does that pay scale work?
The pay scale is going to work how the testator wants it to work. We do generally have a particular normal amount in New York, but if the testator says, this or that, then that's what it's going to be.
All right, now let's talk about the guardians of children that you list in the will. How do you suggest that people talk to those custodians before finalizing their last will and testaments, or do you think that they should?
They definitely should speak to the guardians. They need to make sure that the guardians understand how they would want their children raised, as opposed to how the guardian would necessarily possibly raise their own children, or if they even have children yet. You never want to surprise someone and have them see, oh, isn't that interesting? I now have little Billy. You definitely want to talk to them and make sure that they want to take care of your children and that they understand what it is that you would want for them.
So you mentioned with executors that you go 3 levels down. Do you have the same philosophy with guardians?
Well, we definitely want to have more than one listed because unfortunately in life things happen and there's no guarantee. You could be on vacation with the people that you really wanted to be your guardians at first and all pass at the same time. So you definitely need some contingent guardians there. And it doesn't have to be your family. It can be your family, but it can be somebody else.
So what happens if you die and the person or people that you've selected to be the guardians don't want the job at that moment anymore?
I've actually never experienced that. We normally put down 3 different people, and that's usually a pretty good odds.
So basically, if the first person doesn't want it, then it would go to level 2, then it would go to level 3, and so forth.
Right, and especially if you have put down 3 different people and they weren't your relatives may step forward.
Yeah,
at that point.
All right, speaking of children, how do you suggest that parents give part of their estate to children if they're still minors? You know, oftentimes in my office, when people just have a baby, it seems to be a trigger in their brain. Oh, goodness, I need to have a will. But, you know, what's a 2-year-old going to do if they inherit from an estate?
We regularly include what is known as a testamentary trust in our wills. This is a trust that is only formed upon the death of the testator, and we normally include the language to say that any minor child under the age of blank, up to the testator, some pick 30, some pick 25. There are some that would pick until their child is 50. Will have their inheritance in trust until that age. The testator the testator also needs to designate a trustee for the trust, who does not have to be the same person who is the executor.
So how would you do like a quick comparison between a testamentary trust and a living trust?
Well, for one thing, the testamentary trust really is only after the person passes. So once they've passed, that's it. They have no more choices. Whatever was written in there is written in there. A revocable living trust is something that you can change your mind. You can revoke it. You can make changes. And it's around while you're alive.
Got it. So a testamentary trust can only be amended if the entire will is re-executed. Is that right?
Well, it doesn't actually go into effect until death. So there is no trust until the person passes away. It doesn't exist.
What are some of the disadvantages in using testamentary trusts?
Well, the disadvantage is, for instance, let's say that you do your will and 30 years later, you pass away and you haven't revisited, and you've no longer been speaking with one of your children and those grandchildren for 10 years. They're going to end up getting that anyway, because that's what was in your will. So that is one of the disadvantages. The same as if you had an irrevocable trust. Those also, basically, once it's done, it's done.
What are some big advantages in using testamentary trusts?
Well, the big advantage in using a testamentary trust and the way that we write them is that it's contingent if there are minor children. You wouldn't necessarily want to have that trust otherwise. It only becomes active if you pass away and there are minor children. And these don't necessarily have to be your children. It could be your grandchildren. As an example, let's say you have 3 children and you're leaving your wealth to them, all 3 equally, and one of them passed away a month before you and they have children. So those children, let's say, might step into the shoes of that child and inherit, but they're minor. Even though your 3 children are now adults, there could be grandchildren who are minor. And when we do the language for these things, the way I draft it, I always make sure that we just talk about children and grandchildren. We do not name names, because otherwise, if somebody's pregnant when you die, that child is not getting anything and they're not going to be very happy.
Along those same lines, I've been getting some inquiries lately about pet trusts for companion animals. And I'm just curious if you think a testamentary trust is a nice way to sort of make sure your pets are taken care of.
It could be. I've actually never had that situation in my practice where someone wanted to leave something to a pet. So I have not experienced that myself, but I would imagine that it could be.
So what type of assets pass by operation of law, so to speak, or outside of the will?
Okay, in New York, we have real estate, bank accounts, insurance. Those are all types of assets that are known as testamentary substitutes. In other words, you can name a beneficiary for that type of asset. Sometimes, despite having a will, the testamentary substitutes are all distributed by a beneficiary designation. And then the will sort of is hollow. You're leaving things according to the will, but there is nothing actually there.
Got it. So in that instance, if everything passes by operation of law, does the will actually need to be probated still?
Generally speaking, no. If everything's all taken care of, for instance, if there was a house that was owned by husband and wife, and one of them passes by operation of law, the other one will now own the house. You may still want to get the deed changed, et cetera, but they will own that house. And if everything else was life insurance, bank accounts, that type of thing, there's no need to have a probate proceeding.
In the will itself, should people list their assets and their liabilities?
The better practice is to have an organized file with that information, as the testator does not know when they will die, and chances are that the assets and liabilities will change over time.
So where do you think that organized file should be? Should it be kept in a safe deposit box? Should it be kept in a file drawer that family members are aware about? Should copies be sent to the lawyer on a periodic basis? What do you recommend to your clients?
Well, at this point, surprisingly, more and more older people are actually paying their bills online. And so a lot of this information might be on their computer, but you can certainly have a file. And if your family's getting older and starts needing help with filing systems and things like that, chances are the people who are the executors will already know where those things are located.
How should people give away certain household effects or family heirlooms to specific people in their will or otherwise?
Depending on the situation, some of the items can and are given away during their lifetime. And because they are sometimes given away during their lifetime, I don't recommend specific requests of a particular item. That item might not actually be in existence at the time of their death. As an example, I want to leave my ruby ring to my daughter. If the ring has been lost, stolen, or sold, that daughter may wind up with nothing. It's better to leave it to the executor's discretion.
All right. And should people list their burial information in the will itself?
That's not something I would recommend. It can change over time. Sometimes people buy a plot somewhere, and then it turns out that everyone has moved to California, and you will be in that plot in New York, and nobody will ever come visit your grave. So those are the kinds of things that you can change over time, and you would definitely want to put those with your other important papers.
Got it. So it should be memorialized somewhere just outside of the will.
I would.
Got it. And who do you recommend should really have a will? I mean, should everybody have a will?
I think everyone should have a will, but everyone with minor children, for sure. People who want to give disproportionately to their heirs definitely need one, or leave money to charity would need one. Because if you don't have a will, the state, at least New York State, has a plan for where your money will go. And there's this misconception that the money goes to the government. What it really is they just have a formula for which of your heirs get that money. And you may or may not be satisfied with what that formula is.
Do you have to be over the age of 18 to execute a will?
Yes, you do, in New York.
Got it. So how often do you recommend that your clients revisit their estate plan?
I think it makes sense anytime there's a life change, something like a divorce. Definitely if there are children born, a lot of people these days, they have wills when they're 18 because their mother made them. And then they get married at 35 and they want to change their will. They have a baby, they want to change their will. So definitely any kind of a life change. Sometimes also if you're planning to leave money to an upward relative, meaning you wanted to leave money to your parents, but they have now passed on, you might want to revise your will. So anytime there's a change in your life circumstance.
So we're both matrimonial attorneys, and it's definitely prenup season right now. And the question that I oftentimes get from clients is that if the prenup conflicts with the last will and testament, who is boss? What's your response to that?
I've actually had this come up. I had a client whose fiance had gotten a prenup on a legal site, and he came to me and asked me my opinion, and I had already done his estate plan, and it was a very intricate estate plan, and the prenup from the online site basically said we waive estate rights, and there would have been a conflict. And I explained this to him, and I pointed it out to him. And so he spoke with his fiance, and we wound up doing a different prenup that acknowledged the already existing estate plans.
Ah. So where should people keep their will?
I always tell my clients not to leave their will in the safe deposit box. It's possible that the bank might freeze it as soon as the person passes away. The best place really would be in your home or office in a waterproof and fireproof safe, or with your attorney. I also keep a scanned copy in my cloud storage.
Yeah, I give my clients the same advice. I think a lot of people think that, they take it to their safe deposit box at the bank with everything else, and that's the best place for it, but it will get held up in probate, and that's when you need it. All right, there's a lot of do-it-yourself forms online. So what are some of the pitfalls for people in using those online forms? I know that you had just mentioned a little bit of that waiver with the estate rights, but what are some other pitfalls?
Well, anytime you are using online forms, you're not talking to someone who's skilled at the practice, and they may not know the correct questions to ask, and you may not know that something is relevant. And yes, you will have a piece of paper, and yes, you will have a piece of paper that is called a will, but it may not actually be the best document for you. There's nothing that replaces the advice of an attorney.
All right, speaking of that, so what are your tips in helping people, we've got listeners all over the country, finding the right lawyer to draft their last will and testament, or perhaps, do their entire estate plan for their family?
Well, for one thing, you want to ask them if they have drafted wills with similar circumstances. You also want to ask them if they regularly draft wills and keep up with the law. And then there are some lawyers who in a very old-fashioned manner will do a one-page will for a very, very low price, figuring that then the children will come back and do the probate with them. So they're doing this sort of as a lost leader. That isn't something we do at my firm. I am not assuming that anyone is coming to me afterwards. Everybody these days, has a choice of where they're going to go, and I want to make sure that we have a comprehensive estate plan, and we charge a comprehensive price for it. So you want to ask about that, the fees, what kind of a will. Now, one-page will to me is not enough.
No. Are anything that we didn't cover that you thought would be good for our listeners to understand as it applies to last will and testaments?
I think we pretty much covered everything with regard to the wills. I would love to speak with you further about other estate planning documents.
About the advanced directives, and we'll definitely have you back and to talk more about that. And so, Deborah, why don't you tell our listeners how to contact you and how to find you if they're interested in your services or learning more about the blogs that you've written?
Sure. My office is Kaminetzky Law and Mediation, PC. We're located in Cedarhurst, New York. The telephone number is 516-374-0074. We have a website, www.kaminetzkylaw.com. And I'm in the office, and I also have enough counsel who does nothing but wills, trusts, estates, and probate.
That's great. And so Deborah's out there in Long Island, right east of New York City, where one of my offices is located. Thanks so much, Deborah, for coming on today. I really appreciate your time and expertise.
No problem, Cari. Always a pleasure.
Next up on the Ask Trader portion of the podcast, we have a question from Illinois, and she writes, I'm in a dispute right now, and I just looked at the contract and I saw that there is an arbitration clause. What in the world is arbitration? So to answer that question on what is arbitration, I think the first thing is to try to compare it to other forms of dispute resolution. This is a process that does take place outside of court. So you are not in court if you are in arbitration. It can take place on the side. You can be involved in litigation, and on the side, you're trying to do either binding or probably non-binding arbitration in that context. And it is also not mediation. In mediation, a neutral third party sits and helps facilitate a conversation. Conversely, with arbitration, the arbitrator is going to make a decision, much like a judge. The arbitrator will listen to testimony, look at evidence, and then hopefully then come up with a decision. And that decision, based on whatever the agreement was going to be, can either be binding or non-binding. If it is non-binding, then it is basically just an educated opinion that will help the two parties hopefully reach an agreement. If it is binding, then it is almost like a court order. You'd actually have to take it one step further to make it effectively a court order at that point. I'm trying to do that right now in one of my cases in New York, trying to do what's called confirming an arbitration award, but it is effectively like a court order. An arbitrator has made a decision. And there are attorneys like myself that can do arbitration on the side for an hourly rate. And there are also organizations like the American Arbitration Association that are very organized and can help facilitate arbitration. Arbitration itself is not a cheap process because you're actually paying for that person's time. There could be a one-person arbitration panel or a three-person arbitration panel. And importantly, the arbitrator doesn't actually have to be an attorney. For example, I had a crop insurance dispute a few years ago. And for those of you that are familiar with crop insurance, there is an arbitration clause, and the arbitrator doesn't necessarily have to be an ag lawyer. It could be somebody who is very familiar with crop insurance and those type of arrangements. So that's the nuts and bolts of what is arbitration. I'm hopeful that we're going to have an entire podcast on this topic because it's worth exploring. If you have a question for me for this segment, please be sure to email me at Cari@rinkerlaw.com. That's spelled CARI at rinkerlaw.com, spelled RINCKERLAW.com.